Hi, everyone. Harry here with a quick report on the really important case and oral argument today, Moore versus Harper. It's a little bit arcane, so let me just try to explain it. Here's the idea and why it's controversial. The Supreme Court all the time reviews state courts, but only for federal law. State courts are the final arbiters of state law. But the independent state legislature doctrine would hold that in some circumstances, we'll talk a little bit about what those might be, there would be federal question. The Supreme Court would potentially wade in and overturn a holding of a state court based on state law. And the idea would be that the state court reviewing the work of the state legislature just completely was off the reservation or something like that. It's extraordinary, if I haven't been able to express it right, for the Supreme Court to be doing that. Normally, not normally, invariably, the court and all federal courts take state courts to be the final authority on state law. That's their job. They know it better. They apply it every day. Why would the Supreme Court have a right to do this? Because of a little mention in the federal Constitution that says there are two different clauses, but let me just do the main one, that the state legislatures shall decide the fashion by which electors are chosen. Now, think about this for a second. Had this been the law in 2020, it would mean that state legislatures could make a determination and the state courts could say that violates our Constitution. And the state legislatures could just say, never mind, or federal courts would just say, never mind, the legislature's determination holds. And, state legislatures don't go into depth with legal reasoning. They just do it by political fiat. Oh, and by the way, no small fact here in the background, the majority of state legislatures are in the hands of Republicans. So it is a potential avenue for Republican legislatures to do, you name it, refuse to seat electors and do new ones for Donald Trump, or refuse to make voting requirements or impose new voting requirements that make it harder on voters, etc. And rather than that being judged against the state constitution, even if it violates all kinds of measures in the state constitution, under federal law, if they hold it in this certain way, it would prevail and the state court couldn't do anything about it. Again, just because this word elector is in Article 2. This has always been considered a really wacky theory. There was a mention of it in the kind of disreputable and poorly thought of decision in Bush versus Gore, where Chief Justice Rehnquist, for one other person, sort of floated this idea. But then, lo and behold, in the last couple of years, count them, four members of the new conservative majority seem receptive to this notion. Hey, we're taking a quick break to ask everyone to take a minute to like and subscribe. It's a quick thing that can really help the show. Now back to the video. Okay, so in the argument today, it looked as if there was going to be an overall consensus for the court to recognize this in some fashion. It's not clear where Justice Barrett was, but even so, the tenor of the argument was that they might recognize it, and the question would be more under what standard. So everyone was agreeing, or at least paying lip service to the idea that it wouldn't be enough to say, oh, the state court got it wrong. Somehow the federal courts would have to, again, judging state law, say that the state court here was way out of line, was completely beyond the pale, and based on that and that alone, the federal Constitution reinstates whatever the legislature did. Many problems here, whatever the standard would be. And just to name one, we know from 2020, those of you who, like me, are old enough, know from 2000, passions run very high with elections. And when passions run very high, people's thoughts and opinions are swayed. So in Bush v. Gore, for example, Rehnquist was saying that the Florida Supreme Court was completely crazy, off the reservation, etc. I followed that pretty closely, had slight involvement, and I think most people would agree. No, they were really doing their job. You could quibble with them, but the notion that something crazy or completely activist was happening really was inaccurate. But this would serve it up for federal courts to say that. So potentially, this is why we heard some questions at oral argument, this could mean the end of democracy. If they impose a standard that basically lets state legislatures call the music, even if they're acting against the state constitution, the potential implications could be huge. It could be, in fact, revolution in constitutional election law, and an anti-democratic one, because it would come in precisely when state legislatures wanted to overturn the will of the people and be insulated from review by the state courts, which are normally, always the law they have to answer to. So there you have it, and I hope I've given you an idea of why it's also such a crazy and, to many election watchers, frightening idea. But as with other cases in the court, it looks like some version of it, at least, it will become law, and we'll have to try to live with. Okay, so there you have it. This was a big week in the Supreme Court. You also had the Colorado case involving the website designer who doesn't want to do websites for gay and lesbian couples. So those two combined, but especially Moore v. Harper, make this a very closely watched and very big week at the court. There you have it for my reaction. Seems like a lot's happening these days, so when something big that justifies this kind of extended treatment happens next time, I'll be here giving you my thoughts and reaction. Until then, talk to you later. Thanks for tuning in. If you like the video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.